section because they are very, very short, and I think it'd be easy enough for you to follow along here. All right, we finished paragraph 7. We're going into paragraph 8. This is one sentence: broker fees, all obligations of the parties for payment of broker fees are contained in a separate written agreement. So the contract is between the buyer and the seller. Shouldn't have anything to do with you getting paid a commission. That shouldn't be addressed in the actual contract. So your listing agreement, your buyer's representation agreement, those documents should spell out payment, not this contract. So just keep that in mind. All right, the next paragraph has to do with closing. It says 9A, the closing of the sale will be on or before, and then you give a date, or within 7 days after objections made under paragraph 6D. Remember, we talked about the objections, pool in the yard, or if you object to anything on the survey, the title commitment, the deed restrictions, those types of documents. Or within 7 days after objections made under paragraph 6D have been cured or waived, whichever date is later, closing date. If either party fails to close the sale by the closing date, the non-defaulting party may exercise the remedies contained in paragraph 15. Now we want to talk a little bit about this closing date and being out of contract. You never want to be out of contract. If you cannot close, you want to amend the contract. Everybody's going to have to agree, change the closing date so that you are in compliance with the contract. Now, just because somebody doesn't close, that doesn't automatically mean that they're in default. So, they didn't close. I'm going to keep the earnest money. I'm going to put the house back on the market. We're going to entertain these backup offers, all those kinds of things like that. Be very, very careful about the advice that you give or the actions that you take unless that contract is definitely terminated and that earnest money issue has been resolved. Well, they didn't close today. Well, they might argue, I was on the way to closing. I got hit by another car. I was at Baylor's Hospital when I should have been at the closing table. So you got to be real careful of that. You don't assume anything, or you don't give your buyer or your seller any bad advice. You might say, well, here's the contract. Here's paragraph 15. Here's paragraph 18. I suggest you go see a real estate attorney, but be very, very careful that the contract isn't terminated and that earnest money isn't just sitting out there unresolved. All right, here's what's going to happen at closing. The seller is going to exercise and deliver a general warranty deed. So the title company is going to take care of that, unless it's maybe a relo or an REO, and they might do a special warranty deed, but you don't typically need to concern yourself with that. Showing no additional exceptions to those permitted in paragraph 6, and furnish tax statements and certificates showing no delinquent taxes on the property. Number 2 says the buyer shall pay the sales price in good funds acceptable to the escrow agent. What are good funds? Well, you want to check with the escrow agent. You want to check with the Millennium Title, see what they consider good funds. Typically, cashier's check or certified check would be good funds. A suitcase full of money would probably not be considered good funds. A wire transfer would probably be accepted. A personal check for $200,000 probably would not be considered good funds. So check with the escrow company and see what they require, because it's specified right there. Number 3 says that the seller and the buyer shall execute and deliver any notices, statements, certificates, affidavits, releases, loan documents, and other documents reasonably required for the closing of the sale and the insurance of the title policy. So basically, if they ask you to sign something, Mr. Buyer or Seller, at closing, or they ask you to provide some kind of a document at closing, you're going to do it. Okay. Number 4 says there will be no liens, assessments, or secured interest against the property, which will not be satisfied out of the sales proceeds unless securing the payment of any loans assumed by the buyer, and assumed loans will not be in default. So if you're going to assume the loan, it's going to be current. There's not going to be any other anything owed on that property unless you're going to assume the loan, right? All right, this next one, you should probably be aware of what it says here, because this does come up quite often. Those other four items probably don't come up too much. If the property is subject to a residential lease, the seller shall transfer the security deposit as defined under 92-102 of the Texas Property Code, if any, to the buyer. In such an event, the buyer shall deliver to the tenant a signed statement acknowledging that the buyer has received the security deposit, is responsible for the return of the security deposit, and specify the exact amount, dollar amount of the security deposit. So if there's a lease involved, the seller has to give the new buyer the security deposit. The new buyer has to send a notice in writing. There's no form. You just send a notice in writing. I'm the new owner. I've got the security deposit. Here's how much the security deposit is. All right. The last paragraph we're going to talk about in this section has to do with possession. There's two paragraphs under 10, possession. Buyer possession. Seller shall deliver to buyer possession of the property in its present or required conditions, ordinary wear and tear accepted. So, if you don't close for 33 months or 2 months, there's going to be some wear and tear, normal wear and tear. I mean, but it should be fairly close to the condition that it was in when it went under contract. You didn't rip out some cabinets or take out an appliance or do things like that. All right, so you have a couple of options here. You're going to transfer ownership upon closing and funding. That's the first one. Secondly, according to a temporary residential lease form promulgated by TREC or other written lease required by the parties. Any possession by the buyer prior to closing or by the seller after closing, which is not authorized by a written lease, will establish a tenancy in common relationship between the parties. Now, you might remember back in your Principles 1 and Principles 2, when you talked about somebody being in a property and not having a lease in place, that was not a good position to be in, the tenancy at sufferance. And then this last sentence in bold print says, consult your insurance agent prior to change of ownership and possession, because insurance coverage may be limited or terminated. The absence of a written lease or appropriate insurance coverage may expose the party to economic losses. Now, this is a situation where you want to be very, very careful if the buyer moves into that house prior to closing and funding, or if the seller stays in that house after closing and funding, that you have a temporary lease in place. It doesn't matter if it's for a short period of time, even if it's for an hour. When that thing closes and funds, that's when possession changes. So if that seller moves in, that seller stays after closing, and you don't have a lease in place, you've got this tenancy at sufferance situation again. How are you going to get that person out of there? What's their motivating factor to leave? Go ahead and start the eviction process. I don't care. Or the buyer moves in early, but it never closes. It closes, but it never funds. Something happens. It doesn't fund. Now you've got a buyer in that house, and you have no lease in place. So now you're going to have to go through that eviction process. What are you charging it? Well, you don't have a lease in place. So be very, very careful, and always make sure that I would take that document with you. If you represent the buyer, take a seller's lease with you. If you represent the seller, take a buyer's lease. We closed early. It just hasn't funded yet. The closing agent said, well, I just talked to the lender. It should fund in 2 hours. And the buyer said, well, I've got all my stuff on the van and it's parked out in front of the house. Let me go ahead and move in early. and you give them the keys, but it never funds. But another situation you have, the buyer moves in early. Who owns the house? It hasn't funded yet. The seller still owns the house. Who has insurance on that house? The seller has insurance on that house. Okay. The buyer moves in, they have all their furniture. It's going to be Monday before it funds, but you let them move in over the weekend. You don't instruct them to call their insurance agent and get renter's insurance. Now the house catches on fire, the seller's insurance covers that, all your buyer's possessions are destroyed. They're going to be looking for someone to blame, and that someone's probably going to be you, Mr. Buyer's agent. You didn't tell me about getting insurance, even though it's specified right here in the contract. Well, you never explained it to me. I didn't really understand it. You're the professional. You should know. All right, this is another paragraph as far as possessions concerns, leases. So we've already talked about this in paragraph 9A5. Now here it is again in paragraph 10B. After the effective date, the seller may not execute any leases, including but not limited to mineral leases, or convey any interest in the property without the buyer's written consent. Number 2 says if the property is subject to any lease to which the seller is a party, the seller shall deliver to the buyer copies of the leases and any moving condition form signed by the tenant within 7 days after the effective date of the contract. So you should now know how to explain to the buyers and to the sellers what their obligations are if in fact there is a tenant in that property at the time it is sold. Okay, one thing I want to bring to your attention real quick is we just got this in the mail. It's the latest Texas Realtor magazine. If you're not reading this entire magazine on a monthly basis, you're doing yourself kind of a disservice keeping up with what's going on. Here's an excellent article on some of the contingency issues, and these are pretty short, just questions and answers. You need to always be trying to improve your knowledge about real estate on the legal end. You know, you get a lot of training as far as selling techniques and prospecting and all that kind of stuff, but sometimes we're just a little bit lax on the paperwork end. So you might want to make sure you read that magazine on a monthly basis. All right, that's it for this session. We covered 3 pretty short paragraphs, and we're ready to move on and get this thing wrapped up. Have a great day. Thank you.